April 20th, 2023. We are at the Green Hills Conference Room at the Metro Southeast facility, and we have all the commissioners here and much of the staff, and thank you very much. We have all 5 commissioners here, and the first order of business is to administer our oath of office, which I have asked our executive director to do to each of us. I guess we're going to do this jointly. Thank you.
Y'all you want to seat it or do you want to stand?
Oh, I guess we better stand.
Okay. Repeat after me. I do solemnly swear that I will support the Constitution and laws of the United States.
I do solemnly swear.
Okay, I do.
You better break it.
Break it up more? Okay. I do. A wedding. Okay. I do solemnly swear that I will support the Constitution.
I do solemnly swear that I will support the Constitution
and the laws of the United States.
And the laws of the United States.
And the Constitution and laws of the state of Tennessee.
And the Constitution and laws of the state of Tennessee.
And that I will faithfully and impartially.
And that I will faithfully and impartially
discharge the duties of my office.
Discharge the duties of my office. Thank you. All right. All right. And let me welcome Butch Burns. He's our new commissioner. Thank you very much. We look forward to serving with you, and I think you've met everybody, and hopefully you can meet the staff here. I know you've met some of them, but maybe you can meet the rest of them here right soon. The first item of business, as it is every 2 years, is to organize ourselves. So we need to vote a chair and we need to vote a secretary. So with that, I will just open the floor to discussions, motions, whatever anybody wants to do at this point.
Well, I make a motion for you to be chair and retain your chairmanship.
Is there a second?
I'll second.
Okay, we have a motion and a second. All in favor say aye.
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 Any opposition? With no opposition, the motion carries. So that leaves the secretary.
I make a motion that we nominate Trish Hertzfeld.
All right. I second. Or we have some seconds.
All the seconds.
All right. With a motion and a second, all in favor say aye. Aye. Any opposition? With no opposition, the motion carries.
Yeah.
Right. Okay. Our third item of business is to review the minutes from our last meeting, March 1, 2023. If each of us could take a look at those, and as soon as we're ready to either vote or suggest a modification, please indicate, and I'll recognize you.
I'll second.
We have a motion and a second. Is everybody ready to vote? All right, with a motion and a second, all in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries. The fourth item on our agenda is to consider the poll officials for the Tennessee House District 52 special primary election. Typically, what we have done in the past several years is to approve the entire list of our poll officials. There's many, many of them, and then as we get closer, then the staff will contact those folks and ask them to work. But typically, what we do is basically consider, and if there's no problem, approve the entire list. And how many poll officials do we have?
We've got somewhere what I would call active poll officials in that 2,500, 3,000 range. We have 22 precincts for this special election that we will have to man and staff, in addition to the folks that we have working early voting. So following our practice, we ask that you approve all of our current active poll officials so that we're covered in the event that people get sick, people drop out, whatever. We can immediately fill those positions with other people on the bench.
Any questions?
Mr. Chairman, these would be some of the same workers that normally will work in that precinct area.
Yes, sir.
Okay.
Make a motion to approve.
We have a motion. Is there a second?
Second.
With a motion and a second, all in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries. The next item of business is to consider the early voting schedule for the Tennessee House District 52 special primary election, and I would request our AOE, Mr. Roberts, to explain the staff suggested schedule that is in our packets. It's item number 5 in our file.
Mr. Chairman, we're following the protocol that we established for the August election, in that we're having all of the sites open for the whole 14-day period. And we're recommending that we have 2 sites, one here and one at the Southeast Library. Those 2 sites are chosen because they're within 52. So we think one's on one end and one on the other. We think that'll be a good mix, and we should capture anyone early voting that wants to vote. If you notice on your schedule, your agenda, it says, if necessary, in the event that we only have one person on the Democratic side, one person on the Republican side, and no write-in candidates, we would not have early voting. It would only be election day per the statute. That statute can be found at 214-202. Yes, sir.
And I know that, our voters have gotten so used to early voting, and I just didn't know and I know what you said, what the statute said, but people they love early voting, and that district, I would say, would probably be a pretty big turnout on this election. But now we're saying you got only one shot at this, and that's on election day. So do we have to follow that statute, or is it broad enough that we can open up these early vote sites?
Mr. Starling, my take of the statute would say that we don't have the option because it says that there shall not be early voting. I'll be happy to check with the coordinator of elections with the state just to see.
Would Metro Legal know that?
I don't know off the top of my head, but I can look it up for you.
Okay, and and I'm trying to be as accommodating to our voters, because I mean, people love early voting, and
Right.
Here's a special election, and now we're taking away early voting. You got to come to the precinct on election day. And
Right.
that's my concern with it.
Right.
Can I ask a clarifying question? So when we're talking about early voting for the June 15th, that would be for the primary.
Just the primary, right. The general election, we will have early voting for it.
So you're saying if there is really only one person on one side for the primary and one person on there's really no choice in who you vote for. If you're going to vote, you're voting for
Right.
the one person that's for the Democrats or the one person that's for the Republicans.
And if they vote for themselves, they will move forward to the general election with one vote.
Because they're unopposed.
They're unopposed.
So essentially you're saying your understanding of the law, and Metro Legal is going to check, and state coordinator's office is going to check, is that if both candidates in both primaries are unopposed and there's no independent,
No independent, no
or write-in.
write-in, certified write-in.
no certified write-in, then perhaps there wouldn't be early voting. But we're going to set it anyway.
Just in
to be
case,
sure.
because we don't know, the qualifying deadline is May the 4th. So until that point in time, we don't know who's running.
So if we were to, for some reason, if that were to happen, and everybody's uncontested, we would have to come back and undo this vote to set early voting.
I think it depends on the motion that you make.
Okay?
If you state in your motion that the Republican candidate is unopposed, one Republican and one Democratic candidate is unopposed with no write-in candidates, essentially there aren't two people on the Democrat or Republican ballot that this is the direction you want to go. So I think you could do that with your motion. I might defer to Metro Legal to get them to see if that's going down the right path.
I think personally, I totally understand what you're saying. We don't want to waste taxpayer dollars if we don't need to, because it's not really it's an election, but it's not a contested election at that point. So I get it. But I think for me, just me personally, if we're going to set the early voting stuff now, if we decide we're going to undo that, I think I'd like to do that with the opinions from the coordinator's office and Metro Legal before we do that. So I think for me, I would rather just set the early voting now, knowing that if everybody says this eventuality happens, and the state and Metro both say this is fine, then we'll just come back and say we're not going to do it.
That's fine. Further down the schedule, we want you to set May 4th in the afternoon as our commission meeting.
Perfect.
So that we can approve the candidates to get the ballot prepared so
Look
that
at
we
you
can make a
thinking ahead.
military deadline.
Perfect.
We're working on trying here.
Perfect.
Time's short.
That sounds really great. I appreciate
Okay.
that.
And any other questions? No?
Are we going to get a legal opinion from
I don't know if we're going to get it today, but the suggestion was that we just make a motion that that just sets the early voting schedule, and then if it turns out that there are only one candidate of each party, then we can come back and make the decision, at which point we would have an opinion from Metro Legal and maybe the state.
It looks like it says you shall not have the early voting,
Yeah.
but I'd like to give that some
Sure,
consideration.
sure.
To make sure I'm looking at all the provisions around it.
Okay.
Just to give you some ballpark idea, the election we're estimating will cost somewhere around $120,000. Early voting, 50 of the 120.
Okay. All right.
You're saying for the election itself is 50? I'm sorry. Okay. You're saying for the election itself is 50?
So for the primary on June 15th,
Okay.
total, if we have early voting and just regular election day, that's 120. If we only have election day, that's 70.
Okay. Metro dollars.
No,
Oh, just
these are
within our
reimbursed.
budget.
These are reimbursed by the state. So we will have to collect all of the expenditures, certify those dollars to the state, and then they would reimburse us.
Okay, thank you.
I make a motion to set the early voting schedule as proposed for the June 15th House District 52 special primary election.
We have a motion. Do we have a second?
I'll second.
We have a motion and a second. Sorry, do you have a?
I do have a question. Just make sure. So in doing so, we've covered that provision you've mentioned, correct? Double check before we say.
Yes, we
Thank
have.
you.
Yep.
All right.
All right, we have a motion and a second. All in favor, say aye.
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 Any opposition? With no opposition, the motion carries. That brings us to item 6, which is to approve the date of the absentee counting board for the Tennessee House District 52 special primary election. The date suggested by the staff is June 15th at 9 o'clock. And AOE Roberts, can you explain to us the basis for that staff suggestion?
So this is our typical election morning, 9 o'clock. The absentee counting board will meet to start counting the absentee ballots so that we have those well completed prior to the close of polls that afternoon.
I make a motion to approve. Motion to set the date of the absentee counting board as recommended by the staff.
I'll second.
We have a motion and a second. All in favor, say aye.
Aye.
Any opposition? With no opposition, the motion carries. I do have a question. Now, the election is being held on June 15th. Is that something
That's
that we
correct.
need to set, or is that set by law?
Those are dictated by the writ that we received that I previously sent to everyone by email by the governor.
Okay. Bringing us then to item 7 is the date for the provisional counting board for that same special primary election, and the staff suggestion is June 20th at 9 o'clock. Commissioner Hertzfeld, do you have I recognize you.
I have a motion. I'll make a motion to set the provisional counting board for Tennessee House District 52nd special primary election, June 20th, 9 a.m.
All right, we have a motion. Is there a second?
I'll second.
We have a motion and a second. All in favor, say aye.
Aye.
Any opposition? With no opposition, the motion carries. And then next on the agenda is item 8, which is the date for us to meet to consider certification of that same special primary election. The staff suggests June 20th or June 21st at 1 o'clock. If please, commissioners, consult your calendars and let's discuss those dates.
Mr. Chair, I'm going to be out of the country for both dates, so I don't know if I'll be necessary, but I'm out of the country till the 24th.
What is our time window there to have that meeting?
Our time window is very short because we will start early voting. This is off the top of my head. I think it's the 14th, 16th of July. So that doesn't give us much time to whoever comes out of the primary, get them on the ballot before we start early voting. And the military ballots have to go out on the 16th of July. So we're in a pretty short time frame to get this election put to bed and get ready for the next one.
I actually think I might be back June 22nd. I'm checking my ticket right now. Would June 22nd work, or is it too late?
I mean, we could probably make June 22nd. Well, can we meet in the morning as opposed to the afternoon?
Yeah, sure.
Okay.
If you need me to certify it, I mean, I don't.
We'd like you to be there.
I'd like to be here if I can.
Sure.
Yes, if it's possible.
But the time of day,
I can do morning.
you can do that, Commissioner Davis?
Yes, sir.
Okay.
Okay. So 22nd in the morning,
Great.
I'll have staff double check as to can we get Sunny West. That may complicate things. If not, we'll try to come back out here with the same setup.
One question, Haley. So we're still, even if we do it on that date, just to double check while we're doing it right here and got everybody, we're still good within the time frame?
Yes, the staff are saying if we can do the morning, we think we're not going to have a ton of people running in the primary, so we probably will have a good idea, how complicated it's going to be to change the ballot to put that person on. So we will be preparing ahead of time,
Okay.
So that it doesn't create a glitch.
That's all my question.
Okay. So what time of day on the 22nd?
I leave it to y'all's discretion.
Yeah. Do 9 o'clock?
Oh, yeah.
Okay.
7:15.
As long as she's bringing breakfast, we're good, yeah.
Mr. Davis?
9 o'clock.
Okay.
Nine's okay?
Nine's fine.
All right, 9 o'clock.
Okay, I'll make a motion to set the certification meeting for the Tennessee House District 52 primary election for June 22nd at 9 a.m.
All right, we have a motion. Do we have a second?
Second.
We have a motion and we have a second. All in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries.
Mr. Chairman,
Yes, sir.
is it possible that we can get these dates confined and so we can have kind of cheat sheet because they'll come up on us real quick?
Right. I think it'd be a good idea if I have the staff help us put together a calendar
Yeah.
up through what we know as far as the September 14th date, everything that's going to happen that really someone might ask you about. We have other dates that we have to publish stuff in the newspaper and that, but no one's going to probably ask you about those. So.
Yes, because we got to bring keys, we got to swear in people, we got to do a bunch of stuff. And I know the new commissioner, this is kind of, you'll see, but so just need to, so we can make sure we're on time on these.
Okay.
All right. The next item on the agenda is to hear from our legal counsel. Mr. Dietz, thank you for being here. And there's some litigation we've heard about, and we're hoping you can fill us in maybe in a little bit more detail, particularly about how the schedule is going to go and when, if there is any way to tell when things are going to happen, that would be great.
Yes, thank you, Mr. Chair and Commissioners. So on March the 9th, the governor signed what we call the Metro Council Reduction Act, and everyone is familiar with that act. It mandated a reduction in the Metro Council from 40 to no more than 20. Furthermore, there was a section of the act that required that it be done immediately for this election, which is coming up on August 3rd. There were some default provisions if Planning Commission maps were not approved by the council, but there's no need to go into that now. So we filed a lawsuit the following Monday on March 13th. We argued that the act in its entirety was unconstitutional. We argued that the provision mandating changes in the election this year That section was unconstitutional as a violation of the local legislation clause of the Home Rule Amendment because it only applied to Metro, and members of the legislature, the sponsors, admitted that. It only applied to Metro. We asked the court to enjoin it. And so on Monday, April 10th, we got the order from the court in a 3-0 opinion. This went before the 3-judge court that was created to hear challenges to statutes based on constitutional claims. So we had a 3-judge court. It was unanimous on April 10th, 3-0, that the act was unconstitutional in terms of applying the provisions to this year's election, and the court issued a temporary injunction. We waited all week, and as the days went by, we began to be more comfortable that the Attorney General was not going to appeal. And then on Monday of this week, the 17th, the Attorney General announced that they were not filing an appeal of that. And the Attorney General, in his statement, acknowledged that we are still arguing whether or not the legislature has the authority to reduce the council to 20. But the Attorney General conceded that even if the courts upheld that, it would not go into effect until 2027. So the next regular cycle of Metro Council elections. So what we have left is a lawsuit over the cap itself and whether or not it's constitutional or whether or not it properly applies to Metro. We will argue that in an ordinary course. We have a scheduling conference with the court next Monday, and we anticipate that the court will resolve whether or not the parties are going to have discovery, and if not, then a briefing schedule for dispositive motions. The good news is there is no uncertainty about what happens this year. The election is going forward as it was originally scheduled. A 40-member council, 35-5, election on August 3rd with the runoff in September. So there's no ambiguity about that. There's nothing in the works that will change that. So you may proceed with that assumption in place. Then the rest of the case will play out in the ordinary course, but there is plenty of time to get a final non-appealable ruling from the courts well in advance of 2027. So the litigation will continue. We have arguments that we will put before the court, but for now, we just have a regular lawsuit. Any questions? Yes, sir.
So if the courts were to rule that the state had the right to reduce it to 20, and that ruling comes down after the August election, do we have to have another election to follow that, or do we have to wait to 2027 before we do that?
Commissioner, first of all, I think it's unlikely there will be any ruling prior to August 3rd. But no matter what the ruling is, it will be appealed. It will not be final. Whoever is the losing party will appeal. It will take probably 2 years, give or take, several months to resolve this finally. But no. The August election, and the Attorney General has conceded this point. The August election will go forward. Council members who are elected in the election this year will serve a 4-year term. And to the extent the state prevails and Metro must reduce the council to 20 or fewer, then that will take effect in 2027, not before.
Okay. Thank you.
Any other questions? So I take it you can't think of any course of events that would cause cause the Metro Reduction Act to be implemented before 2027?
I believe, based on what General Skermetti said in his statement on Monday of this week, the state will not be seeking to impose the act on the Metro Council prior to 2027. So if that's the state's position, then it's extremely unlikely that the court would do something other than what the state is asking for in terms of relief. Absent that statement in his press release on Monday, there was theoretically a possibility we could litigate this, and then the Supreme Court could mandate the implementation on some irregular schedule. But since the state is not seeking that, apparently, based on the statement on Monday, we don't believe that will happen.
All right. Mr. Chairman.
Yes, sir.
What happens to the piece of legislation that was passed? They passed a piece of legislation, and now they're just trying to figure if it's unconstitutional. So if they find it unconstitutional, what happens to the legislation?
So, Commissioner, the part of the act, there was only a part of the act that was declared unconstitutional. It was Section 1B that mandated Metro reduce the council this year and go through all the hoops to approve new maps and have an election on August 3rd for 20 or fewer. That part of the statute, applying it this year, that's stricken. It is not the law, and it is now essentially moot. So that part, Section 1B is gone, but Section 1A is still there. And Section 1A says that notwithstanding any provision of a metropolitan government charter or statute to the contrary, the membership of a metropolitan council must not exceed 20 voting members. So Section 1A, which is the cap itself, that's still alive. The court has not determined that to be unconstitutional. So that is what we are litigating. What is over is whether or not the state can make Metro implement the act this year. That part of the case is over. That part of the act has been enjoined and is essentially stricken.
Any other questions? Thank you.
Thank you.
That brings us to the AOE report. Mr. Roberts, do you have anything further to talk to us about?
A couple of things. We've received, or candidates have picked up, approximately 90 petitions so far. We have not had a lot turned in with their signatures yet, so every day that goes by, that makes us nervous because we have to get more done in a shorter period of time. So we're hoping that the candidates will secure their signatures and drop those off just as quick as they can. A couple of things that we are going to do to make sure we don't have any glitches. We are going to be reviewing, taking a closer look at residency, specifically the time frame that you have to have been a resident of Davidson County or a resident of your district, and if based on our voter registration records, if there looks to be any issues, we'll reach out to the candidates to try to resolve those before the qualifying deadline. If we can't resolve those, we will ask that the commission hear those on May the 4th. Resolve those. The candidate will still have time before the 18th qualifying deadline to address any issues that the commission feels. So we're essentially, if you remember the last time we went through this process, we were delaying sending out military, all of that kind of stuff, because we had people were contesting the residency. We're trying to get those taken care of on the front end. So that's the plan. And I spoke with the coordinator of elections this morning describing how we were going to do it, and he thought that was probably a good idea. Yes, sir.
So we're going to start investigating on the residencies of those people that pick up petitions or turn in petitions. Is that that's something new, right? We hadn't always done that.
We have not done that in the past.
Okay.
And if you remember the last time we had some of these issues, we were pushed up to the wall trying to get those issues resolved early. But these are black and white issues. If you have to be a resident for 3 contiguous years and your voter registration only has you 2.5, and we've got you registered in another county prior to that, you need to come tell us what's the issue. How is that going to happen?
So in other words, you will be able to contact the candidate that's running and let them know that you have some concerns over this.
That's correct.
Okay.
We've got 2 right now that have pulled petitions for the wrong district. They don't even live in that district. We have to find out, do our records, are we missing something, or what is it? Because currently you don't live in that district, but you said that you did.
You know, and I'm just trying to, we got a lot of attorneys here, but I'm just trying to make sure we're not going outside of our responsibility as a commission and doing investigative type work. And is that part of what we should be doing? Or should we follow what we've been doing if it was complaint about the residency requirement from a citizen?
In speaking with the coordinator, he said that you were charged with making sure that people qualified. So
I'll just say that from Mr. Legal's point of view, I agree. You have a duty to make sure people are qualified. So if you have information on its face that says this person doesn't live in this district, you know, it's fine to ask them, can you show us that you do live in this district?
Okay. Yeah, I just, you know, this is new. And you know, I'm just trying to make sure we stay within our
And I think if you, we're still likely to have residency challenges because they've got 2 residents and this is not to address those. This is to address the ones on face value, you don't pass the test. We can't see from our records, your voting history, that you qualify for the required time frame.
Right. I just didn't want to see us get in no situation where we approve someone and someone that lives in this neighborhood and said, no, that's not true. So are they challenging us? Are they challenging?
And that's why, similar to all of the challenges that you had the last time, we had already essentially put up on the website that these people were certified. And you went in and dealt with the challenges. What we're trying to do is, on face value, if we don't think they're passed, there's some question. Let's try to get those resolved up front. And it could be very simple.
And you know, and I'm just saying, if individual says that A.J. Starling doesn't live in this community, the election commission says yes, he does, and he's been qualified. So if a challenge comes, do they challenge the election commission, or are they challenging that candidate?
Oh, they're challenging the candidate because we are trying to verify what the candidate is telling us. Remember, the candidate has said that they on the petition it says all of these facts are true and whatever. But on face value, if you have to live in Davidson County for 3 years and our voter records show you didn't, I think we have an obligation to that candidate to try to figure out what are our records incorrect, or is there something else that, we didn't know about?
So basically, we're doing a deeper dive into checking these residences on all the people that turn in the petitions.
Right. So just like if we check to see if you live in the district, we're going to check to see if you've lived for council. Have you lived in the district for 6 months?
How did we check that?
How we check it on just our voter registration records,
okay.
just nothing else.
Okay.
That's all we have to check by.
Yeah, and the ones that we've had those issues with, people coming in with photos and all that kind of stuff.
Right, but they're usually contesting that I've got 2 residences and I live here part-time and they're part-time. These are going to be more black and white issues.
Okay.
When a candidate comes in and qualifies and they say, I qualify for the following reasons, they swear that under oath, right? Isn't it, I declare under penalty of perjury?
Correct.
Okay, so we already have that statement, and I appreciate the effort here. I'm not trying to throw water on it because you're giving people more time to correct stuff that doesn't jam everybody up. So I appreciate the effort, but I think I share Mr. Starling's concerns that turning us into an investigative body could get pretty sticky. Has there been any consideration of doing maybe a watered down version of some of the documents we'd asked for in some of those, where we could say, hey, give us a utility bill and and a rent and a...
We're looking for something very simple, not that would change it from, we don't see it in our records, to, okay, now I understand what happened or whatever.
Like a prima facie case? Like just a little bit more? Like
A little bit more that, okay, we've got an error in our voter record. The date that we say you moved out of county was not correct.
I'm a little concerned about it because they are swearing it under oath.
And
so I do feel like that's evidence, right? I mean, if they're swearing it under oath, that's evidence.
And that's why I brought it to the commission, for you to help us decide, are you good enough with them swearing that this is all truthful? Some people, and I'll give you the example, this is complicated for them and they may not understand. If you don't know what district you're in, even though you voted in that district 3 times already, you just don't understand.
I have a question, and it might be directed at our legal counsel, but my question was, where in the statute is this addressed, so that we can take a look at it and decide whether we are going too far under the law. So, Ms. Fox, you look like you were ready to tell us something.
I'll pull up the statute in a second, but I believe that it's your duty to put qualified candidates on the ballot. So I think they come to you and they are saying that they live in this district. But I think if you have information in your possession that contradicts that, I think it's very reasonable for you to ask. It looks like you were registered in another county for the past 3 years, but you're supposed to have lived here 3 years. Can you give us some explanation? And then I think that the election administrator would make some determination of whether or not he thinks the person is qualified to be on the ballot. And if the person who's trying to qualify disagrees with Mr. Roberts' decision, that can be appealed to the commission, and then the commission would have the opportunity to have a full hearing, as you have in the past, hopefully not quite as long, but because I know those were very tedious, but you'd be able to look at more evidence about where do they, sleep and where do they get their electricity and all those kinds of things, if further inquiry is required. But I don't think Mr. Roberts is not going to be kicking someone out and they're not, without any remedy. Right. But I think that you do have a duty to put qualified candidates. And so, for example, if you brought in an 8-year-old and he swore that he was qualified to be there, and you can look at him and see that he's not the correct age, you're allowed to say, well, can you see some evidence that you're qualified? I think if it's apparent on its face.
We're trying to weed out those ones that are likely to come to you potentially anyway, that someone could contest whether or not they are challenged.
So what you're talking about is, so now I think I'm understanding it a little bit better. Are you in agreement with Ms. Fox that that's what the process would be?
Yes, right.
Okay, I don't have quite as many concerns with that. If it looks really obvious that this isn't it, you make that determination,
right.
And they have the ability to appeal it. Like, I don't want us getting involved in all that. I don't want to be digging through everybody's receipts, and I don't want to be doing that.
Right, and kind of to set the stage, we have a commission meeting set for May the 4th, if we follow here. So people that have picked up a petition beginning March 20th until now, we have kind of a list of folks that we want to follow up with.
One other thing, if an individual has a issue with the residency, would they come straight to you and you'll try to resolve it before you get to the commission?
No, if they're going to challenge, they would follow the practice that you have had before. What we're trying to do is, some of these we should be able to clean up ahead of time. Let's get those out of the way so that you're dealing with just the challenges in that short time frame.
So we're not eliminating anybody's ability to challenge.
No. So everyone will still be able to challenge. Okay. Everyone would still be able to appeal the decision that we make that says we don't see the evidence here that you've met the residency requirements to the commission. But we're moving some of that effort earlier so that we can handle it in a more timely basis.
And one other thing, and I'll be through, I promise. Is this something that's going to be done statewide, or is this just Metro Pacific?
When I asked Mark, he said that it's not exactly the same across every county. And part of that has to deal with how many people run in the county, how many people move around a lot in the county, those kind of things. If you're in a very small rural county, those people haven't moved in 20 or 30 years. Here, we're having people move from Davidson to Wilson to Williamson and back, and within short periods of time. And we checked with Metro Legal today to make sure on mayor it's 3 years contiguous. It's not, over 20 years you've been here, 3 years in Davidson County. So that's not even clear. If you read the charter, you might need someone to help you a little bit understand exactly what it says in there. So we're going to try to reach out and help those people early. And it'd be, reaching out would be, on our petition, we require them to give us an email. So email, and we'll follow up with a letter so that we can get their process started quickly if there's any concerns. This is not an effort to kick anybody off. It's an effort to make sure everyone is qualified that we put on.
When the staff reviews the number of signatures, what do they refer to when they check the signatures, the numbers, and whether the signatures are from the right district?
So I'll give you the high level. Kelly's here. She can tell you exactly what she does. But our system allows you to go in, and it will tell you whether or not this person's in that district At the same time, we can review their signature. We can, if we need to, we can then look deeper. How long have they lived? Did they just move there? All of that kind of stuff we can look at. But usually, if the system tells us it's in the district, signature looks good, that's what we're going to go with.
So are you saying then that as to other issues, principally residency, we would be basically doing the same thing, just looking at our own records?
Looking at just our records, nothing else.
Not looking outside of our records.
Right. And if our records, we can't get that candidate over the hurdle, we're going to reach out to the candidate to say, we only have this. Are we missing something? Because without something additional on face value, you don't meet the residency timeline.
Okay. All right. I would still like to put our eyes on the part of the statute that governs this. Is it possible? I mean, we've got a few things left on the agenda, including looking at our cards. If it's possible to punt this one issue to the end of the agenda and then get back with Ms. Fox to look at it a little bit harder and give it another look. Is that acceptable to everybody?
Yes.
Yes.
I mean, I will say that I'm looking at TCA 25204, and it said each qualified candidate's name shall be placed on the ballot. I mean, I think
That's all. It doesn't say anything more than that.
it's talking about and then how the process for how you do that and how someone will withdraw. But I'm saying that because I think that you are only allowed to put qualified candidates on the ballot.
Sure.
I'll see if there's anything else, but that's one of the things that I've noticed.
Laura, I think if you'll look in the duties of the commission, I think that's one of the defined duties in there.
Okay. All right. Okay.
Also, in your packet, we've included, just for your information, our efforts over the past school year on what we've done, both public and private schools, as far as school registrations. So you'll get, there's a mix in there of, the school wants us to come in and do one in person. The school wants us to send them the registration information, or the school has identified someone to be our designee that we work directly with. And Mary's here. She can tell you kind of what we do. We have a bench of poll officials that we send out on a regular basis to do this work. But to just give you some idea, Davidson County has a lot of schools when you add private and public that we have to reach out to make sure that we meet that requirement in the statute. Any questions? Mary's here if you do have a question on this. If you think of something, just let us know. We can follow up with you. One other thing that we will be working on over the next few months, the legislature passed a bill, the school safety bill, that requires all doors in schools to be locked at all times. We currently have polling places in 64 schools. That's not a problem usually for known elections. So the August election, the runoff in September, all of 2024, the known elections were covered. It's when we have a special election that's 55 days from the point of knowing about it. That's not in the school calendar. I've talked to the vice mayor, and he is going to convene a meeting with all of the parties involved to see if Metro can have a plan in place should this come up to address the new law.
Okay.
That's all I have, Mr. Chairman.
Okay, thank you. Has anybody signed up for public comment? Ma'am? What's on our sign-up sheet? Oh, Kelly's going to bring it. Okay. Ms. Martin Norman, you've signed up for our public comment. Thank you. Come on forward, and we'd like to hear from you. Thank you for coming to see us. Let's see. There. I think you have to push the button on the right, and it'll turn red, and then you're live.
Thank you.
Okay.
Good afternoon. My name is Arlene Martin Norman. I live in District 27, and I just wanted, and I know you guys didn't spend a lot of time on talking to this. I thank you for the opportunity to speak, first of all, but you didn't spend a lot of time talking about this. But this is my voter registration card. And when you did the redistricting during the 2020 election, I almost threw this away because it came so flimsy that I thought it was junk mail. And I don't know how long you've been using this format, but it's very flimsy. Is there not some way that it can have heavier stock, that the mailing can look more official? That was my concern, because I'm thinking going forward, we may have more new voters, new people getting cards, and they may not look as closely. I almost threw it away, and something just told me, you better open that and see what it is. They may not look that close, and they may throw their card away. And then I also worked to pose as a volunteer, and so there's a lot of people that showed up, and they were at the wrong place, but they had the old card, and so just wanted to make you aware of that.
Thank you. AOE Roberts, can you address that, please?
We're thinking on the same path, Ms. Norman. So we have worked with the printer to secure a heavier weight paper. Back during COVID, we got caught in the supply chain issues. That was the only paper we could get. And when you're printing 400,000 at that time, the paper just wasn't available. So we have secured paper. It will still be white. One of the things that we're adding on the outside when it comes to you is important election information or something along that lines, just so that you'll see that and maybe be able to know that it's something you need to pay attention to.
Thank you.
Okay.
And thank you for your comments. We appreciate it. Okay. We have a suggested date for our next meeting as May 4th at 3:30. AOE Roberts, can you explain to us the staff's reasoning behind that date?
Sure. May the 4th is the qualifying deadline for the House 52 at noon. We'll have the meeting in the afternoon. Withdrawal deadline is the 8th. We then have to have the ballots prepared for the primary to send out on the 16th, I think it is, for the military. So we've got a short window to get cranked up and get those out. That's why we need you to meet with us on the same day that qualifying ends, that we can move forward.
Commissioners, is that date acceptable?
Yes.
Make a motion to set.
We have a motion. Do we have a second?
Second.
We have a motion and a second. All in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries. Next.
Mr.
I'm sorry.
Chairman,
Yes, sir.
let me make a couple of announcements to the May 22nd, I think, was what date did we just talk about on the 22nd?
9 a.m.
22nd at 9 a.m. of June. That will be in the June 22nd meeting at 9 a.m. will be at Sunny West. So they have availability there. We also need to look at your calendars for May the 30th. That
For what?
for a commission meeting.
Okay.
The reason behind that, May 18th is the deadline for qualifying for the August 3rd election. The 25th is the withdrawal deadline. The earliest date we could get at the Sunny West was the 30th. So if you're good with that, that would be our preference, to have another commission meeting on the 30th. We're okay anytime during the day on the 30th. It's available.
I've got a problem in the late afternoon, so if there's another time earlier in the day, that would be great with me.
Sorry. Why don't you guys just do 8:30, 9 o'clock?
Mr. Chairman,
Yes, sir.
I apologize. The first things I speak when as commissioner, I'm asking for a little leeway. I've got a friend from out of town that I've had a long scheduled breakfast with him. So, I mean, if we could do it anytime after 10, that would be
okay.
helpful.
All right. Okay. Sure.
Thank you, sir.
10:30?
10:30.
Whatever's good, we're good.
Okay.
10:30. All right, well,
And we will get a list of all these dates. Yeah.
We will, and I apologize. Even Metro Legal has told us that I need to do better on getting these dates out to everyone, especially around the meeting. We were pushed to the wall because, we didn't get the governor's writ until Wednesday, so things are on a very abbreviated schedule, and we're just trying to make sure we get these dates before the public as early as possible.
I'll make a motion to set the meeting May 30th at 10:30.
We have a motion. Do we have a second? Do I have a second?
I'll second.
Thank you. With a motion and a second, all in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries. Now, this was not on the agenda. This setting of this meeting is not on the agenda. So I think we just have to make sure that we send out a notice of that, don't we? Right?
We will send out the notice of the meeting, as we always do. That's not a problem. We just needed to, my error, I didn't get that on the agenda, and I'm trying to think we need to get this tied down pretty quickly.
Absolutely. All right. The next item on the agenda is to review our cards, which is always, a pleasure, and we're going to do it again. And for if anybody's watching, under state law, the commissioners are required to review a selected number of registration cards and verify their accuracy. So we do this in a public meeting. So for the next maybe 20 minutes or so, you'll be seeing the commissioners looking through these cards, and a Democrat and a Republican will review each card.
Mr. Chairman, for clarification purposes for the new guy.
Yes, sir.
So,
Oh, I'm
what am I
sorry.
looking at?
Yeah,
I mean, I
you want
see, I know what I'm looking at, but what am I looking for, I guess?
Oh, yeah, we need. Is there?
This is what you're going to sign.
yeah. That's afterwards.
So the name is missing, addresses, any of this stuff
So
missing.
basically, okay, missing, okay.
Right. Missing information. There's some, if you see something that's missing, then we can discuss it. Some of it is fatal and some of it is not.
And you may see multiple types of registration forms. You've got a state form, a federal form, a form that comes through the Department of Safety, a form that comes through our online voter registration. So if you have any questions, just flag me down here.
Mr. Chair, you have to read several of these provisions together for the qualification issues. May I send you just an email about it later? Is that okay? Or,
Yes.
I mean, or I can show
But
it to you.
But if you can tell me now and then maybe follow up with an email,
Sure.
that would be great.
Yeah.
Since we're basically going to be looking at these cards for a
Okay.
while, I can come around if that's okay. Or do you
Sure.
think it? Okay.
I mean, I was looking at 25202,
Okay.
25204, 206, 207, and then 211, 202. It looks like it's kind of a joint effort between your commission and the coordinator of elections because
Right.
you both have a role.
Right. So you said 211, so that's
211,
252. 211, 202. Mm-hmm. Wait a minute. So is that 25211?
25202, 25204, 25206, 25207, and then 211-202.
I see. Okay, I got you. Okay.
Like I said, it's a little bit much, so.
Okay. All right.
Well, and I'd like to look at the AG opinions and see if there's anything in that as well.
Okay.
Yes, but I'm happy to talk about these with any of you.
Okay. Yes, and Mr. Dietz, we appreciate it. Thank you for coming and talking to us. It's always a pleasure to hear from you.
My pleasure. Thank you. And we are here to serve. So
Okay.
thank you.
All right. we have just reviewed. Okay. Ready? The commission has just reviewed the registration cards as we do on a quarterly basis and have signed off on a form certifying that we have done so. So with that, there's just a very few things left to do. One would be to adjourn, and I believe we've already set our next meeting on May 4th at 3:30, and we will also lock and seal the provisional bags and absentee bins for the Tennessee House District 52 special primary election. And what happens there is that the commission, one Republican and one Democrat, seals those bags so that they are locked up in preparation for that special election. And we do that here at the Election Commission, and it's open to the public, and we will do that immediately following this meeting. So with that, is there a motion?
Before your motion, let me just mention one thing.
One more thing in the AOE report.
The Y in Madison has notified us that our room will not be our standard room. It will be very cozy. We will be pushing it to get 4 precinct registrars for early voting into the room. So it may mean for the presidential cycle, we will have to find a different location.
That's for the which Y?
The Y out on Galton Road.
Okay.
Okay.
Motion to.
Oh, yes,
Just
yes,
point of
Mr.
order.
Burns.
Did we decide about the issue?
Oh, I'm sorry. Thank you. Perfect. We did not. We were going to come back to that issue about the staff checking into qualifications for the candidates and signatures and residency and all like that. And we were going to get an opinion from our legal counsel, and Ms. Fox has started working on that, but she's got a long way to go because there's a lot of things to review. Kind of my take on it is that we do have this duty under the statute to not put anybody on the ballot that's not qualified, and it would be, I think, remiss if we didn't at least check our own records to determine that they're qualified. And then if there is some issue, that we try to notify the people so that they could come in and address the issue. So, and we're not doing things, or the staff is not anticipating doing things really much different than we've done in the past, which is basically not to do an investigation like we would think of in the common parlance, but look at our own records to determine whether there's some problem out there, and then to notify the people, and then consult with Metro Legal to make sure that we can comply with due process so people will have a chance to address the issue. And I think that Ms. Fox has looked at this a little bit so far, can give us kind of a brief report about that it appears there's really no law that directs us on what kind of due process to apply. So that's my statement, but I want to just open up the floor because we didn't completely address it the first time it came around.
So I don't think there's anything to vote on because it's not on the agenda, but I appreciate the knowledge and the information, and I would suggest maybe after Ms. Fox and whoever else is finished with their analysis on what it is we're doing here, perhaps the administrator could just do a, one page, here's the process, here's what we're doing, so it's pretty clear that it's limited and it's not just we all had an idea in our heads and whether our minds met or didn't, and we don't end up in a fight about it later. And if you could just have a policy, something like that, and then circulate it to us, and if any of us have an issue, we can ask for it to be on the agenda. Is that okay?
Is that satisfactory with everyone? Okay, all right, fantastic. Okay, which brings us back to a motion.
My motion to adjourn.
And do we have a second? We have a motion and a second. All in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries and we are adjourned. Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.